All right, welcome back to the Deep Dive. Today we're going to be getting into something that I think a lot of renters are probably curious about. It's this whole idea of how to actually go about filing for a hardship stay of eviction. So we've got a bunch of stuff, some legal briefings, FAQs, things like that, to really kind of break this down. And I think what we really want to try to do today is just, give everybody a good, solid understanding of, what a hardship stay actually is in the first place.
Yeah.
And then also just kind of lay out those typical steps that would be involved if somebody needed to pursue this.
Yeah, and I think it's a really important thing to keep in mind right off the bat that even though we're going to give a general overview here, these procedures and these deadlines can vary depending on what court you're in. So while this is generally applicable, it's super important to look into the exact rules for your area. So for instance, if you happen to be a tenant or renter in Orange County, Riverside, San Diego, or Los Angeles and are facing eviction, you can find some helpful resources at martinezlawcenter.com.
Okay, well, let's just get right into it then. Let's start with, just the very basics. What exactly is a hardship stay of eviction? What are we talking about here?
So, in the most basic terms, a hardship stay of eviction is a way for a tenant to ask the court for more time to stay in their home. When they're facing eviction, and this is due to some, significant financial or personal difficulties, it's basically a request to the court. You're asking them to kind of put a pause or a stay on enforcing that eviction order. In some cases, the landlord might have even already obtained a judgment to, get the property back.
So even after, a landlord's kind of gone through that whole legal process, this hardship stay could potentially put a hold on things.
Exactly. It gives the tenant a little bit of breathing room to try to resolve those underlying issues, the things that led to the eviction in the first place. Or, it just gives them a little extra time to find another place to live so they're not immediately displaced.
Makes sense. So, in what kind of situations does somebody typically, seek a hardship stay? What are some of the reasons that this might come up?
Sure. So generally, tenants seek a hardship stay if they would face, some sort of extreme hardship if they were evicted immediately. So common examples, we see this with a job loss, someone's income's drastically reduced. Maybe there's some serious medical issues going on that affect their ability to work or pay rent. And then the other big one is just, lack of any alternative housing options, within a reasonable time frame.
It sounds like it's not just a matter of saying, things are tough for me right now. You actually have to show that there's a real significant hardship happening.
Yeah, that's exactly right. You need to demonstrate to the court that the hardship is temporary and that you, as the tenant, are actually making efforts to resolve it. The goal here is to convince the judge that with a little bit more time, there's a chance you'll be able to get back on your feet or, find somewhere else suitable to live.
So let's get a little bit more specific. What would be some examples of what a court might consider a significant hardship? Like what kind of evidence really matters in these cases?
So as we mentioned, financial distress is a big one, right? Something like a sudden job loss, medical bills piling up. Those are things that courts tend to take seriously. And then, on the personal side, it might be that a tenant genuinely has nowhere else to go. Or maybe they're caring for family members, dependents, people with specific needs that make it really difficult to move on short notice. Any of those circumstances could potentially be considered. And here in California, the legal standard is that the tenant has to convince the court that they would face extreme hardship if they were locked out. That's actually right in the California Code of Civil Procedure, Section 918. That's the section that gives the court the ability to grant a stay in these situations.
Okay, so let's say, somebody's in one of these tough situations. What are the general steps they'd need to take to actually file for one of these hardship stays? Where do they even start?
Well, the first thing, and it's often overlooked, is communication with the landlord. It's always a good idea to, explain your situation to them, be open about the challenges you're facing. You can even propose solutions like a repayment plan if it's an issue with back rent. Just be upfront and honest.
I'm guessing, though, that just saying it isn't enough. You probably want to have some record of that conversation, right?
Absolutely. You want to document everything, save emails, keep copies of letters, even a log of phone calls with the dates and times. All of that can be really valuable if you need to use it as evidence later on. And then after you've communicated with your landlord, the next big step is really gathering all that documentation to prove the hardship. This is super important.
So what kind of documents are we talking about specifically?
Well, if you're trying to show financial hardship, you'd need things like termination letters from your job, pay stubs showing that your income's gone down, maybe bank statements. If it's medical issues, you'd need medical records or bills. You also want to show the court that you're being proactive, so any letters or applications for rental assistance, unemployment benefits, anything like that would be helpful. And then you'll also want to write out a clear explanation yourself, detailing the hardship and how this extra time would help you resolve it. Basically, tell your story, but back it up with evidence.
Okay, so you're putting together a strong case. What happens after you've got all the paperwork?
Once you've got all your documentation, the next step is to really dig into those local court procedures. And I can't stress this enough. The exact steps and the deadlines for filing what's often called a motion to stay execution are different everywhere. Eviction laws vary from state to state and sometimes even within a state.
I guess that makes sense. There's no single set of rules that applies everywhere.
Exactly. You need to look up the rules for the specific court handling your eviction case. You might be able to find this information on the court's website, or you can call the clerk's office and ask about the procedure for filing a motion for a stay. And once you know what those procedures are, then it's time to actually prepare and file that motion.
What does that look like, actually preparing and filing the motion?
So usually you have to fill out a specific form. It might be called motion to stay eviction or something similar. You'll attach all your supporting documents, the evidence you've gathered. There might be a filing fee, but you can often ask for a fee waiver if you can't afford it. Sometimes you might also need to do a sworn statement and affidavit of hardship, where you're basically saying under oath that everything you're claiming is true.
Okay, forms, documents, fees, all that. What happens after you file the motion with the court?
Most likely, the court is going to schedule a hearing to consider your request. And if they do schedule a hearing, it is so important that you attend. This is your chance to actually talk to the judge, explain your situation in your own words, and answer any questions they have.
I can imagine that going to court is pretty intimidating for most people.
Yeah.
So let's talk about timing here. Are there any, critical deadlines that people need to be aware of?
Timing is absolutely crucial when it comes to hardship stays. Generally, you need to file your request after you've received an eviction notice or a court judgment, but before the eviction is actually enforced. So before law enforcement, like the sheriff, comes to actually remove you from the property.
Sounds like waiting till the last minute is a really bad idea.
Exactly. In a lot of places, you only have a few days after receiving the final eviction order, which is sometimes called a warrant of removal, to file for a hardship stay. Here in California, after a landlord wins an eviction case and gets what's called a writ of possession, the tenant needs to file their motion for a stay under that section we mentioned before, CCP 9A to A, to try to delay the sheriff coming to the property. The bottom line is, don't wait. Act quickly.
Got it. Time is of the essence. So when a judge is looking at all this, trying to decide whether to grant the stay or not, what kinds of factors are they thinking about? What are they weighing?
They're going to look at a few key things. First, how serious is the hardship? What exactly is going on? They also want to figure out if the hardship seems like it's temporary and if you, the tenant, are taking reasonable steps to fix the situation. They might also consider if you've paid any of the rent you owe or if you've generally tried to follow the rules of your lease agreement.
So the tenant side is important, but what about the landlord? Do they have a chance to say their piece?
Oh yeah, absolutely. Landlords can definitely object to a hardship stay. They can give the court reasons why granting the stay would be unfair to them. So in California, under that CCP 918A, while the court can grant a stay if the tenant shows extreme hardship, the landlord can argue against it. It's a two-sided process.
Okay, so let's say a hardship stay is granted. What does that actually mean? What happens next? What are the outcomes and the conditions?
If the court decides to grant the hardship stay, they'll issue an order saying how long it lasts. It could be a few weeks, maybe a couple months, depending on the situation. And the court is likely going to put some conditions on the stay. The most common one is that you have to keep paying rent during the stay. Sometimes the judge might even say you have to pay some or all of the back rent you owe as part of the deal.
So it's not just a free pass to live there rent-free for a while.
No, not at all. The court might also have other conditions, maybe requiring you to look for a job and show proof that you're trying, or to apply for rental assistance programs. And it's really important to understand that if you don't follow these conditions, the court could lift the stay and the eviction could proceed. As we mentioned, in California, if you get a stay under CCP 918, you usually have to pay the ongoing rent while the stay is in effect.
What if the court looks at everything and decides not to grant the stay? What happens to the tenant then?
If your hardship stay request is denied, you'll generally have to move out by the date in the original eviction order. Your options might be limited at that point, but you could see if you can appeal the decision, if that's possible in your area. You might also need to start looking for emergency housing help right away, from local resources or organizations, so you don't end up homeless.
This whole process seems like a bit of a legal maze. Is it something that people should try to handle on their own, or are you better to get some help?
It's possible to represent yourself in these situations, but honestly, I would strongly recommend getting legal help if you're facing eviction and thinking about filing for a hardship stay. These laws can be very complicated, and the court procedures can be tricky. A good lawyer who knows about tenant rights in your area can give you the right information, help you with the paperwork, and even represent you in court. It can make a big difference in the outcome. And for those of you listening who are tenants in Orange County, Riverside, San Diego, or Los Angeles and are facing eviction, remember there are resources at martinezlawcenter.com. They can definitely help you out.
That sounds like some much-needed support for anybody going through this. So as we wrap things up here, what are the really key takeaways you want our listeners to remember about hardship stays?
The most important things are that timing matters a lot. You have to understand the rules for your specific area, and you need to have strong evidence to support your hardship claim. And don't wait. Take action as soon as possible.
And it sounds like trying to handle this without a lawyer can be a really risky move.
It definitely can be. That's why getting legal advice from someone who knows the landlord-tenant laws in your area is so crucial. They can walk you through the process and make sure you're protected. And again, for our listeners in Orange County, Riverside, San Diego, or Los Angeles, check out martinezlawcenter.com if you're facing eviction. They can help you navigate this.
So to leave you with one final thought, take some time today to research how hardship stays work in your area. Knowing your rights as a tenant before you're in a crisis can be a huge help. Thanks for joining us on The Deep Dive.
Call now 714-442-9741. Thank you.